The High Court has handed down a judgment in the Prince Harry against the Sun case in the phone hacking claims, and depending on which headline you read, either Prince Harry is set for a court showdown with the Sun, that's by the BBC, or by the Telegraph, Prince Harry's case against the Sun publisher has been thrown out as the judge brands the palace claim implausible. As always, there's probably a little bit in between, and I'm here to explain what I think, and I'm going to refer to some parts of the judgment as well, so stay tuned. Welcome back to the channel. So there is quite a lot to go through in this judgment. I won't be doing it all at once, but what I am going to say is that the headlines don't really give you a full and proper picture of what's been going on here, because in some sense, I think they've just been polite in that they are not jumping on certain words within the judgment, but not that I'm going to jump on those words. I'm going to use certain words that the judge has used so that you can get a real feel for what the judge actually said in this case. But moving back to those headlines just for a moment, moving across to the Sky News version, which is a little bit more neutral but a little bit more accurate, says Prince Harry can take part of the damages claim against the Sun publisher to trial, which is a little bit more accurate because part of it is what will proceed, and what I would describe as the main chunk of it will not proceed. Whereas if you look at the BBC article, no criticism BBC, but I think this is a little bit too headline grabbing for the BBC, set for a court showdown with the Sun. Yes, technically it's true, this part of this case will go to court, and the rest of it is explained within the article, which you'll have to read to understand it fully. But coming to the point and the way that the judge has described this case overall is essentially that the evidence is not plausible, the case is inconsistent, and just to give you a brief background as to what this particular judgment was about, it's that the Sun came to court to apply to strike out the claim or for summary judgment, usually made in the alternative. So if it doesn't succeed on a strikeout, the court has the option to provide summary judgment, and made that application on the basis that this claim was brought out of time. Harry then wanted to change essentially his pleaded case to rely on what he called a secret agreement between the palace and the journalists to not bring certain claims until a certain point in time. Now, his case was contradictory in the sense that he didn't originally rely on that secret agreement, as he now puts it, and you'll find out in a minute what the judge thought about that alleged secret agreement. So let's move to just a few snippets that I've brought out for you. There is a lot more to it than this, but as you can tell by my background, I'm not in my usual settings, so I'm just going to go through a few here because news happens when it happens. And so I'm going to go through a few here. These are just a few choice snippets from this judgment, which is a public document. Everybody can read it. And I suggest that you do read it to get the full flavour of everything within it, just in case you misinterpret what I say, and that is available online. The few that I've brought out first of all, and I'll probably break these into separate videos, but this first one here. Prior to the strikeout and summary judgment application having been made, the Duke's case was not that he was aware in 2013 or 2012 that he could bring a claim, but rather that he was unaware that he could, save only that he'd been told in 2006 about one incident when his mobile phone was hacked by the News of the World. His case was not underscored, and that's relatively unusual in a judgment unless it's really to emphasize a point. His case was not that he was informed in about 2012 that he could not bring a claim at that time, but that he was discouraged from bringing a claim in about 2018 on account of assurances given by NGN senior executives that royal complaints would be resolved later. So, in other words, he's changed his story somewhat. In this paragraph here, paragraph 36, let me just check that it's actually on screen properly. The Duke's evidence is therefore contrary to his pleaded case, that in about 2012, there was considerable activity in the royal household addressing and bringing voicemail interception claims. This included being told that there was further evidence that he'd been hacked by Clive Goodman. However, it was desired to keep members of the royal family out of the witness box, and so a secret agreement had been made with senior executives at NGN, the result of which the Duke could not bring the voicemail interception claim that he could otherwise have brought. Moving on to paragraph 42. Importantly, there is no evidence in the Duke's witness statement to suggest that he became aware of new facts relating to his phone hacking claim against NGN between about 2012 and 2019, when he went to solicitors to issue a claim. There is therefore nothing identified that made him realise that he had a worthwhile claim to bring beyond what he knew before the application date. The reason for the delay, he says, was his understanding that he could not bring the claim in 2012 or subsequently. He eventually became dissatisfied with being made to wait. His claim was issued before the end of the that's the previous phone hacking litigation. Then there was some discussion about the application to amend his pleaded case being brought late, and at paragraph 69, the court said no proper explanation was given in the evidence for the lateness of the amended application. Mr. Sherborne said in his submissions that it was only when considering the evidential response to NGN's application to strike out that the Duke's lawyers were focused on the legal consequences of the factual case, and the lawyer's understanding became fuller once one saw the witness statement that was prepared in response to the limitation application. That's in a roundabout way saying that they more fully understood the factual background of the case once they saw the witness statement, which is not entirely unusual, but to amend the substantial pleading of the case, it would probably be detrimental, as I've said in previous videos. If Mr. Sherborne's assertion is accepted, it does at least explain why the estoppel plea could not have been advanced by way of amendment before the Duke's witness statement was prepared. So there I said it's not entirely unusual, but not entirely helpful at the same time. However, this does not explain why the Duke's factual account changed from his pleaded case and is put forward so late. There was no explanation as to how the Duke was unable to remember, before preparing his witness statement, that the secret agreement about which he was told in 2012 was the reason why he did not issue proceedings against NGN then. So just breaking that down, there is no explanation as to why he changed his pleaded case, and no explanation as to why he just couldn't remember that this secret agreement existed, and that was the real reason that he couldn't issue proceedings beforehand. Remembering all the time that this whole case, this whole application to strike out was on the basis that it was brought late, as in there's a limitation period beyond which you cannot ordinarily bring a claim. Nor does it explain why, following the witness statement, a draft amended reply was only produced on the first day of the hearing of the application. Paragraph 71. The obvious inference to draw is that the Duke did not remember in March 2021, when the reply was filed, being told of the secret agreement and relying on it in or about 2012, and only remembered it when he reviewed the 2017-18 correspondence with Sally Osmond to prepare his evidence to respond to the NGN application. But again, that's the only obvious inference, but given that the now asserted facts are said to make it unconscionable for them to rely on the defensive limitation, it's surprising that, when setting out his case in response, that he did not recall his reliance on the secret agreement. This is a little bit of court code speak for I don't really believe it, at least as it is in my experience very often used. It's surprising that he didn't remember. In other words, possibly he did remember and didn't mention it, or worse still, that someone has made it up. The Duke did not react to the defence by asserting that NGN was unfairly relying on limitation. Instead, he signed a statement of truth on a reply that said he was not aware or told that he had a claim until 2018. And so that would directly contradict the pleaded case about this secret agreement. So he signed a statement of truth to say that he wasn't aware or told that he had a claim until 2018. Now, being told or being made aware is possibly different to being aware, but one would be aware if you had a secret agreement to prevent you from doing so. So if that was the real reason, that ought to have been explained fully and properly from the outset, and not in a contradictory fashion to change your pleaded case to make it implausible, which, as we'll go on to see in a moment, the judge ultimately found this to be. Paragraph 73. The terms of the secret agreement contended for by the Duke are surprising in themselves. Again, the use of the word surprising is sometimes used, not saying that it is here, but is sometimes used as a way of the court saying, we don't really believe this, but this is what's contended. Contended, argued, just put forward. The pleaded case, reading on, is that it was agreed between NGN and the palace on his behalf that Prince Harry and his brother, among others, would bring claims against the defendant only at the conclusion of the previous phone hacking litigation, and at that stage the claims would be admitted or settled with an apology. This, if correct, would require the princes and others to issue a claim at a later stage, thereby giving publicity to the complaint, which the palace did not want, rather than seek to resolve it in private. Further, the terms pleaded committed NGN to admit the claims brought later or settle them, without knowing in what terms the claims would be brought. This seems inherently unlikely. In other words, if this agreement did exist, it would have committed NGN to admitting and settling claims that hadn't yet been brought, hadn't yet been pleaded, in terms that they did not know, on this basis of some secret agreement that happened beforehand, that they would be settled later rather than bringing them to court. And in other words, the judge just didn't accept this. This seems inherently unlikely is code for I don't believe that, unless the secret agreement related only to the Goodman hacking. But that is not his case. So again, use of the words there to suggest that the court's just not buying it. Moving on, these paragraphs in succession, paragraph 74. In trying to force a settlement and apology in 2017-18, having been given permission by Her late Majesty the Queen to proceed, the Duke, Prince Harry, was therefore acting contrary to what he contends are the terms of the secret agreement, which required the royal family to bring claims only at the end of that litigation. The evidence in support of the pleaded case is limited to that of the Duke, Prince Harry. It is not strong evidence. The Duke is unable to identify between whom the secret agreement was made, or even who it was who told him about it. His case was that it might have been Gerard Tyrrell, a solicitor who acted for the royal family, or it might have been someone else at the institution. The original pleaded case was that the Duke became aware through the legal advisors that his family in about 2018 that he could bring a claim against NGN. But by the intended amendment, that is to be changed to his becoming aware that he could bring a claim in 2017 after permission was given by the Queen. Given that Gerard was acting on behalf of Prince Harry in 2012 in connection with the phone hacking and other matter, one might have expected to see some evidence from him or from Ms. Osman or Sir Christopher giving support to the Duke's factual case, but there is none. So, in other words, if there was evidence of all this, if this did really happen, the judge would have expected to see some evidence of it. The documents in evidence from 2012 do not support a case that a secret agreement was made at the time. And the upshot of all that in paragraph 77 is that the difficulty that the Duke faces here is twofold. Firstly, to adduce credible evidence that the secret agreement existed in 2012, and secondly, that he relied on such an agreement. Moving on and somewhat summing up before I come back in other videos to do more detailed analysis of this. This is the news version. Paragraph 78, in my judgment, it is implausible that the Duke did not remember before March 23 if a secret agreement was made, as he now alleges, that made it unconscionable for NGN to rely on a limitation defence at all. The Duke pleaded a case in March 21 that was inconsistent with the estoppel case, relying on section 32 to delay the running of the limitation period. He then reaffirmed the inconsistent case in November 21, even while pleading that he was discouraged from bringing a claim in 2018 because of assurances given by NGN senior executives about a resolution once that previous litigation had been ended. It is not, in my view, realistically possible that the Duke confused assurances about which he learnt in 2018 with a secret agreement on which he positively relied in 2012 by not bringing a claim. Nor does he say that he did confuse them. There is simply no explanation. Speaking more about the evidence in paragraph 80, that evidence which describes being kept out of the loop by the palace and learning in 2018 of an agreement not to engage about claims until after that litigation was over, is inconsistent with the Duke's evidence in his claim that he was told in 2012 about a secret agreement and relied on it then, by not bringing a claim in about 2012 or after. Paragraph 91. For all the reasons that I've given, I'm unable to conclude that there is a sufficiently plausible evidential basis for the new case based on the secret agreement to justify the grant of permission to amend at a late stage of the proceedings. The lack of credibility arises from the unexplained lateness of the plea, linked to the nature of the estoppel plea, the improbability of a secret agreement being made in the particular terms pleaded, the inconsistency with the Duke's currently pleaded case, which is twice supported by statements of truth, and his witness evidence in other proceedings, supported by a statement of truth. The absence of any explanation for the new factual case being raised, and the absence of any other witness or documentary evidence to support it. So, in other words, there's contradictions, there's a lack of evidence, there are self-contradictions within his own statements and his own case, and ultimately, a lack of credibility. And in conclusion, at paragraph 142, the judge concludes that I consider that the Duke's claim for voicemail interception and other wrongs accessory to any voicemail interception are time barred, both in relation to the News of the World and the Sun. That is because the Duke has no realistic prospect of establishing at trial that before the application date he did not know and could not with reasonable diligence have discovered facts that established a worthwhile claim in that regard. Only the remainder of the claim must still be tried. That was other unlawful information gathering techniques, but not the voicemail interception, or otherwise referred to as the phone hacking. So that is a brief overview of what's been handed down and decided just today. Obviously there will be much more to discuss, much more analysis, but make sure you hit the subscribe button and notification bell to receive those. And as always, thank you for watching.